Rakesh, my colleague, is joining us on the broadcast to talk more about this. Rakesh, अगर आप मेरी आवाज सुन पा रहे हैं?
देखिए, बड़ी खबर आ रही है सर्वोच्च न्यायालय से चुनावी चंदे पर एसबीआई को सीधे तौर पर निर्देश दिया गया है कि बॉन्ड से चंदे की पूरी तौर पर जानकारी दे। एसबीआई ये जानकारी चुनाव आयोग को देगा, ये सर्वोच्च न्यायालय ने कहा है। 6 मार्च तक एसबीआई देगा चंदे की पूरी जानकारी। 31 मार्च तक चुनाव आयोग की जानकारी वेबसाइट पर देना होगा। चुनावी चंदे पर एसबीआई को सीधे तौर पर बातें कही गई है और आम चुनाव से पहले सर्वोच्च न्यायालय ने जो बातें कही है, जो फैसला दिया है, वो काफी अहम है। 31 मार्च तक चुनाव आयोग जानकारी वेबसाइट पर दें, ये सीधे तौर पर कहा है। चुनावी चंदे पर एसबीआई को एससी का सर्वोच्च न्यायालय का निर्देश, बॉन्ड से चंदे को दे जानकारी। एसबीआई ये जानकारी चुनाव आयोग को देगा। तो ये बड़ी बातें हैं जिसको आपको समझना होगा, इसका सीधा असर आपको पड़ेगा। तो इलेक्टोरल बॉन्ड पर सर्वोच्च न्यायालय का सुप्रीम फैसला। जी
राकेश, सर्वोच्च न्यायालय ने यह भी कहा है कि जो राइट टू इंफॉर्मेशन एक्ट जो है, जो उसकी एक जो सीमा है, वो कहीं ना कहीं लांघी जा रही है इलेक्टोरल बॉन्ड्स द्वारा। और पॉलिटिकल पार्टीज में भी जब ये डोनेशंस दी जाती हैं, जो गुमनाम डोनेशंस होती हैं, उसकी वजह से पॉलिटिकल जो फेवरिज्म है, क्विड प्रो को जो बोला, उसको मद्देनजर रखते हुए कोई और इंतजामात होने चाहिए। राकेश,
देखिए, इलेक्टोरल बॉन्ड एससी ने रद्द की। इलेक्टोरल बॉन्ड स्कीम असंवैधानिक स्कीम से वोटर्स के अधिकार का हनन और अब तक मिले चंदे की जानकारी सीबीआई ये एसबीआई माफ कीजिएगा, ये साफ तौर पे कहा गया है। तो ये बड़ी खबर है क्योंकि एसबीआई को ये सीधे तौर पर जानकारी देनी होगी। तो ये बड़ी खबर है और इसका असर सीधे तौर पर पड़ेगा। तो आम चुनाव से पहले जिस तरह से ये फैसला आया है वो काफी अहम है।
राकेश, इस जानकारी के लिए हमारे साथ जुड़ने के लिए आपका बहुत बहुत धन्यवाद। All right, electoral bond scheme will have to go. The Supreme Court categorical that this is not going to stand. It violates a number of articles in the Constitution. KV Dhananjay, senior advocate, also joins us on the broadcast to give his point of view on this. Mr. KV Dhananjay, appreciate you taking out the time and speaking with us. What does this mean for political parties? And the Supreme Court has said that this is null and void. It's been annulled. Is there any reactive legal recourse in sight, according to you?
Well, there is not, I don't think there is anything for the government to do now other than to fall back on the old scheme that used to be there. This was, I think, somewhat expected because the law on electoral funding is not something that the Supreme Court evolved only in the last few years. It's been there for a very long time. And the courts have taken such proactive measures in these areas. Now, there used to be a point of time when courts said that if political parties don't get their accounts audited, then they would not even be entitled to the exemption under the income tax law. Now, there was a point of time when, that was in 1993, when the Supreme Court said that political parties that have not filed their income tax returns and knowingly have done so shall be criminally prosecuted under the Income Tax Act. So what you will see in the Supreme Court so far as electoral reforms is concerned is that there is a pattern, and what today's judgment does is to fit nicely within that pattern. So there is just no going back to, a variation of the electoral bond scheme, because the judgment, I understand, is very comprehensive. And in that view of the matter, what the judgment essentially strikes at is this anonymity. Because there have been so many cases in the past, including in the Supreme Court itself. You had a chief minister of a prominent state who was in fact given a donation by a loss-making company. The Supreme Court took note of that in 2012 and said that why would a loss-making company make a donation? And more so, it later was also known to the Supreme Court that people associated with that loss-making company had received benefits from the government, not from the chief minister per se. So there was a CBI inquiry ordered against the chief minister by no less than the Supreme Court itself. This was in 2012. So, what the electoral bond scheme does is to allow companies to donate unlimited sums of money to political parties. Now, companies are these strange entities from a layman's perspective, and managers of a company who are known as directors who sit in a board of directors. So they are not dealing with their grandfather's money. They are dealing with shareholders' money. This new law says that they can deal with shareholders' money however they want. They can donate as much money as they want to political parties without disclosing anything. And they will not even disclose how much they've donated to whom, to their shareholders. A law like this, I don't think would have survived any, democratic court's scrutiny. So I think that is how one has to look at it. I have no doubt that the government might have actually intended that this will usher in an era of clean money. But then again, India is, you have to trust the international rankings and see that India is so low on the corruption index. So having great intentions is not enough. You also have to see the reality on the ground. And also the fact that there was disproportionate receipt of, 65 to 70% of all money that came in through electoral bonds went to the BJP. That, I think, was also a huge factor that, in fact, would point at quid pro quo. But that's the way one has to look at it. And this was quite well expected. I mean, we've tracked the Supreme Court's judgments in the last 40, 50 years in regard to electoral reforms. So this was inevitable. I mean, there was no other way to, there was just no option for the Supreme Court. That's the way I would like to look at it.
Right. And Mr. Dhananjay, the Supreme Court also said that this is violative of Article 19. The right to information is also something which is far superior than any donation made to a political party. This is obviously, the highest standard of upholding the Constitution.
Very true. And the rationale for the electoral bonds anonymity was that if the public should get to know who is donating to whom, then the donor would be subject to political retribution and all that. Now, that's an argument that is rather belied by the fact that in India, two of the biggest corporates in India, the Tatas and Birlas, were in fact donating money to political parties. They've never raised any objection to the fact that whatever they were donating to and how much they were donating to was all in public domain. So if Tatas and Birlas are not going to be, if we don't find them having a problem, how do you expect the small fish be able to come out and say that they want to donate so much of money to political parties, but they are afraid of retribution? Well, the biggest companies were not afraid of retribution. By the way, the Tatas and Birlas are in consumer. They deal with consumers. They have so many consumer-oriented businesses. I mean, these are not petroleum companies that are dealing with just big corporates. These are huge two business conglomerates that have everyday businesses where consumers actually come in. So if these businesses didn't have a problem with transparency, it's really so difficult for the government to make up this argument that political donors wish to remain anonymous. I mean, why would the small-time fish actually fear anonymity? And your point that privacy, the right to privacy includes the right to receive information, I think yes. And it's entirely possible that today's judgment of the Supreme Court over the next 12 to 15 months would be cited in several other international jurisdictions, because there are a lot of other countries where debates are ongoing on the extent of anonymity that political donors should receive. So it's entirely possible that India, being the largest democracy in the world, and the Supreme Court's verdict being this clear, this emphatic, could in fact have international ramifications also. More so in a country like US, because in the US Supreme Court had gone on to say that corporates have the power to remain anonymous and then to give unlimited political donations. Now that judgment is such great criticism in the US, and it's possible that the Supreme Court of India might have just done something that over the next 1-2 years, it actually could, create an international, impact too.
Right. Mr. Dhananjay, appreciate you joining us. Tulsi K. Raj, Senior Advocate from the Supreme Court, also joins us to talk about this. Tulsi, appreciate you speaking with us. I hope you can hear me.
Yes, I can.
Well, a big decision coming in. The Supreme Court is obviously saying that the Constitution mandates that transparency is most important, because if it's not done in that fashion, then the right to information, the Article 19, which guarantees you transparency, is being violated. Though it's a setback for political parties, it does uphold the Constitution, to the highest degree.
Yes, it's in fact a major breakthrough, major development, and it's going to be one of the most important pronouncement in modern contemporary constitutional law. And I don't think it is, it is a judgment which is going against political parties per se. It's actually it's a judgment that goes against the norm of monopoly in electoral politics, and that is what I think the judgment actually militates against, which I think is in consonance with constitutional values of equality, liberty, and political autonomy. The idea is when there is absolute non-transparency in electoral donations, certain political parties, as we see in contemporary India, get a kind of monopoly to control elections and politics in such a way that is unmatched by any other political party. And this is made possible only because of the element of money in electoral politics. And this is what the court has today said is not in consonance with what the Constitution stands for, what the preambular words of the Constitution stand for, and the established principles of transparency and certain fundamental rights that are available to the citizens as voters and as citizens. So this is a very important development today, and I also think it comes at a time when the Supreme Court is generally facing some criticism of not standing up against the executive as much as it should as a counter-majoritarian institution. So this is a very interesting development that comes from the court at a time when the court, I think, is facing one of the most stringent criticism after the period of emergency in post-independent India. Right. So I think the judgment is certainly a welcome move.
You're quite right, Tulsi. Mr. A.K. Jha, political analyst, also with us on the broadcast. Mr. Jha, what do you make of this? This is a big setback to political parties right before the Lok Sabha elections. But, according to the Supreme Court and the Constitution, this is something which had to go.
Yes, definitely. As far as this decision is like, I think it is going to impact political parties, no doubt about it. But so far as the kind of funding which political parties, the ruling political parties have been getting, it is not a new phenomenon. It has been there since independence only. Of course, and that was one reason why this kind of model had been adopted by Modi government itself. So it is the creation of Modi government that it wanted to at least restrict some of the the kind of funding which political parties had been getting was not known to people at large, and to contain it and to restrain it, Modi government did it, and that is one good aspect what this government had done. But the another side is that so far as the bonding was concerned, it was kept anonymous. And the bonds could have been bought only in the SBI, and expectations were that since the SBI is a government public enterprise, government has the monopoly of getting the information of the people who are buying this electoral fund. That was one, of course, that was one of the valid reasons, no doubt about it. In that way, in the light of this contention, it can be seen that, the judgment which is going to be there will have some repercussions to other political parties. But the other thing which Madam was speaking about, that I have some reservations on those things, that, the judiciary is not only supposed to go every time against the executive. It is not necessary that executive decision, whenever is there, must be condemned and must be contained. After all, the executive has the power to take a decision, and executive takes always wrong decisions, and judiciary has to come over there to restrict it. I think that is too far to go. That argument may be good on the part of the people from bar, but I think as a general people from a general public, I think that should not be the outlook of the judiciary. Also, I am not going to say anything on judiciary because that is not.
Okay. Mr. Vikrant Sharma, Advocate Supreme Court, also with us on the program. Mr. Sharma, if you can hear me.
Very much.
Well, what are the ripple effects of this huge decision that comes via the Supreme Court today on not only the elections, which are just a few months away, but also the kind of funding political parties have been receiving for the past few years, courtesy electoral bonds?
The thing is, basically, what I just wanted to say is the judiciary is playing its own role and a major role. Just because of one reason, if we see, if during the past so many years, even the funds which are being generated, which are being the expenditure done by the parties during the course of elections, they are on a very higher side, and there is no explanations for the cause. There is they have mentioned about the schedules which they have to file about their assets and other expenses, and there are schedules also that under these guidelines you have to do the expenditure. But if we look into the reality, that when the expenses are really on a very higher note, and to check all those things, I think the election commissioner has failed to perform its own part, because they have not taken such harsh decisions against the candidates also, and against the people, those who are spending a huge amount of money into that thing. So it needs to be checked out. And unfortunately, there are so many reasons when the judiciary has to come in between and to resolve its problem, and to give a judgment pertaining to all these issues. So this is very, you can say, unfortunate part of the people, and it is an unfortunate part of the judiciary also, that every time judiciary has to come into the picture and give a guidelines to those things.
Right. Let me also once again rope in Tulsi into this conversation. Tulsi, is there a recourse that the government can use at this point in time?
Not really, because it's a constitution bench judgment coming from the apex court, and there is the only legal recourse to any judgment that comes from the apex court is to file a review. But the grounds for review are quite limited. You can only file a review petition in the court if there is a error apparent on the face of record. So that's usually done for fundamental errors that are crept into the judgment. And this is certainly not that kind of a judgment, not that kind of a verdict. It's a constitutional issue, and the court has considered the contentions of all the parties, of the petitioners as well as the government, and it's a well-considered, well-thought-out judgment. Therefore, the government will be compelled to implement this judgment in its entirety, I believe.
All right. Okay. Mr. Jha, the Supreme Court also went on to say that under the garb of these electoral bonds, a lot of quid pro quo used to happen. But, that would have happened any which ways, right? With or without the electoral bonds.
Definitely. That is one reason where so far as the judiciary had to come in and to take a decision, they have taken it. And that is in the interest of the democracy itself, no doubt about it. But so far as the illegal funding is concerned, that is, there are several other routes through which such kind of funding can be done. But then that will be a different course where people had to look into it, because so far as the electoral bond, purchase of electoral bond was concerned, the kind of anonymity which was still kept must have been brought into the light, and people should had the right of knowing what amount of funding is being given by which particular group of people, and so in that sense, definitely we must celebrate this decision of the highest court of the judiciary, and that is one thing. But so far as the illegal funding, the funding of the kind which from other sources are concerned, that will always be there. So far as and this is not new to India only. This has been there in other democratic countries also. We have seen in USA, and we have seen in some other democratic countries also. These are the limitations of democratic functioning. But then government will have to come out. If government is trying to look into it more seriously, it can find out some other solutions. But in any case, I don't think government will be very much interested in restraining other sources, other ways through which it can be funded by different organizations. I think they will let it go as it is going. But so far as this particular bond was concerned, this has been a very good judgment, and now government will find out some other ways if they are really interested in getting some other fictitious kind of funding for this. But this is not only the political parties which is in governance. There are other political parties also which are supported by different organizations, and they keep getting such kind of funding from different places. So in any case, all the political parties have something, I won't say hand in glove, but they have something common interest. So none of them are really very serious
All right.
as to restrain it. That is one very difficult side to take note
You're
of.
absolutely right, Mr. Jha.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.